o'clock, so we'll go ahead and get started. Welcome. I'm Christy Taylor. I'm the Executive Director of the Texas Judicial Commission on Mental Health, and we are so excited to start talking about this important topic of not guilty by reason of insanity. Couple of housekeeping matters. We are asking that you put any questions into the Q&A. The chat can be comments and chatter, praise, but it'll be easier for us if you have a specific question that you want one of the speakers to address, if you could try to put it in the Q&A. We are recording this. It has been approved for 1.5 hours for CLE, and we will post the CLE number, the QR code at the end. I want to thank our speakers, and it's hard to do this in the summer with vacations and all the rest of life that's going on. So we are definitely grateful to our speakers. Also want to thank our partners at HHSC. They've helped plan this, and they will be integral to the part 2. And I want to thank Kylie Phillips, who is the wizard behind all of this, behind the scenes. Okay, so as you all know, I'll keep this short, but the insanity defense is one of the most discussed but least understood doctrines in criminal law. Often we hear about the public focusing on the verdict itself. And what I am learning along from these experts is that the NGRI verdict is not the end of the case. And in many ways, it's the beginning of a new legal process. So this is a 3-part series. Today is the foundation. We'll go over things like the legal definition, distinguish this from competency, the role of the experts and the rigor of that process, and the court processes surrounding NGRI. In part 2, we're going to go more specifically and follow the case after the verdict. We will then hear from the experts that work on the inpatient side about commitment, treatment, risk assessments, and the role of the state hospital system. Part 3, that will be in August, we are going to explore the conditional release, the ongoing court oversight, the difficult balance between individual liberty and public safety. So that is the big picture. There might be some of those topics in 2 and 3 that our experts touch on today, but then they will pause for some of that to be carried out in more detail in July and August. So taken together, we hope that this provides you a practical understanding of the entire NGRI process. And this is just really the beginning of a learning process. HHSC is developing a toolkit that we're going to collaborate on. I think this will be a topic at our summit in November. So just consider this an ongoing conversation. Okay, let's get to our esteemed panel. So we have Krista Chacona. She's an Austin criminal defense attorney who practices at the intersection of mental health and the law. She represents individuals with mental illness and IDD and has extensive experience in guardianship, civil commitment, competency, and insanity. She has also previously served as a special hearing master for Travis County Probate Court at Austin State Hospital. Next, you'll hear from Dr. Maureen Burrows. She's a board-certified forensic psychiatrist in Austin. She has nearly 2 decades of experience in conducting forensic evaluations and providing that expert testimony in both criminal and civil matters. She is experienced in probate, federal courts, and she is an affiliate faculty member of the Dell Psychiatry Department at the Dell Medical School at UT Austin. And our third speaker is Judge Nelda Cassiotti. She is a JCMH commissioner and is currently serving as an associate probate judge in Tarrant County. But don't let that fool you. She has spent decades in the criminal side. She previously served as the chief of the mental health unit in the Tarrant County Prosecutor's Office and was a mental health magistrate for Tarrant County Criminal Courts, where she handled competency, insanity, civil commitment, and diversion. So by the time she learns all of probate, she's going to be the whole mental health picture. So I'm excited to hear from these speakers. Our format today is each of them is going to present for about 20, 25 minutes, and then we're trying to leave room for questions at the end. And again, put those in the Q&A. And I promise you, we will send out the PowerPoints. It is a pet peeve of mine when people say they send out the PowerPoints and they don't. So we will get those PowerPoints to you. And with that, I will turn it over to Krista.
Thanks, Christy. So I'm not sure exactly who all's in our audience, but I assume it's mostly lawyers and judges. And although many of you have probably been practicing for years or on the bench for years, it is still possible that you've never dealt with an insanity case. So it wouldn't surprise me if you didn't know much about NGRI, but you really need to. As we come to understand more and more about how the human mind works, and we gain more specifically forensically trained experts, we as a system are now better able to identify and litigate these issues. Insanity is certainly not a new phenomenon. Since the beginning of the civilized world, humans have acknowledged that it is immoral to punish someone for something they did not understand as wrong. And yet there are people who really don't like it. They think it lacks accountability, that the person should be punished. And there are a lot of misconceptions about what NGRI is and isn't. And for all of the attention it's getting lately, NGRI is a very rare disposition. It is used in less than 1% of felony cases as a defense, and less than 10% of that 1% is successful in Texas. And although we are willing to acknowledge it, and that may ebb and flow, mental illness is real. It is serious. And now that folks are tracking the numbers, we know it impacts far more people than some folks previously realized. So I'm going to start real quick with just some of the crucial facts and some mental health basics. So thanks to the good people at NAMI and SAMHSA, we have numbers that track nationwide the people, adult and juveniles that experience mental illness in the U.S. and those who have co-occurring substance abuse disorders with their mental illness. This is not surprising, but what I want to draw attention to is when you compare that to the number of individuals in the criminal justice system that have a mental illness, and those numbers increase dramatically, double and triple in some instances, especially when you're talking about people who have a dual diagnosis. And we all know that many of the children in the juvenile justice system also have been diagnosed with mental illness. There have been lots of studies, including a local study that verified these numbers, and we know that nearly half of people who are shot and killed in interactions with law enforcement also have a mental health condition. And I'm starting here because if you are part of the criminal justice system in some way, you are likely to encounter someone living with mental illness because nearly 50% of people passing through our doors have a mental illness. A couple of the basics to start with. Before you even meet your client, there are ways that you can pick up some signals that you may be needing to look for a possible mental health issue. Where the clients are housed in the jail, sometimes the probable cause affidavits will mention some odd behavior, and you can look to see if the magistrate ordered a 1622, which is a mental health assessment. A lot of people think that if their client is really difficult and doesn't want to listen to reason and they can't talk to them, they must be mentally ill. But not every mentally ill or not every difficult client is mentally ill. And not every client living with mental illness is incompetent. Even fewer are insane, which means that not every client with a diagnosis needs a competency evaluation or a sanity evaluation. And one of the most important things to remember is that if a client is competent, even if they are diagnosed with a mental illness, they are permitted to make all the same decisions that any other client would be, including bad decisions that are against our advice. I'm not going to talk too much about the law on incompetency, but we're going to touch on it as well as some of the other speakers because it's really important and it is very misunderstood and it is often confused with the laws and the rules regarding insanity. Each of these, incompetency and sanity, they each have very distinct and different definitions, purposes and goals, and very, very different rules. And it really is important that you know the difference. Although they both involve the existence of a mental illness, competency and sanity are just truly two very, very different things. So most of you were probably familiar with what is deemed the definition or the test found in 46B as to what the standard is for a finding of incompetency. That's important, but what I think most people really need to know is Section 024. This is only section 1 of 4 sections, but this is where the code outlines for the doctors what the factors are that should inform the doctor's opinion as to whether or not someone is competent to stand trial. So 024 is really the more important of the two sections. Most of the rules and processes around insanity, as you know, are found in 46C. But the actual definition or the test, if you will, is found in the penal code. And it requires that at the time of the conduct charge, the actor, as a result of severe mental disease or defect, did not know his conduct was wrong. So I want to break that down a little bit. This is an affirmative defense, which means that the defendant has to prove the insanity, and they have to do so by a preponderance of the evidence. They have to do it and prove that the insanity existed at the time of the conduct charged, not before, not after, not today. You could be sane today. It doesn't, it's sane or insane today. It doesn't matter. It's at the time of the conduct charged. It has to be a result of a severe mental disease or defect. Substance abuse doesn't rule out an insanity defense, but it cannot be the reason that you didn't know what you were doing was wrong. It has to be the result of a mental illness, mental disease or defect. It can't be antisocial. If you have antisocial conduct, if you have an antisocial personality disorder, while that is in the DSM-5, it is specifically not a basis for an insanity plea. The actor essentially has to know that their conduct was wrong, which in Texas means that it was illegal. And the tricky thing about insanity here is it's not usually as hard to prove that the client didn't know their conduct was wrong, but it's sometimes harder to prove that they didn't know it was illegal. So they may have a general idea that society considers what they did to be wrong, even if they didn't. And importantly, your client has to be determined to be competent before an expert can evaluate them for insanity at the time of the offense. So I want to take a minute to compare and contrast some of the key elements of competency and sanity. So with competency, you're presumed competent to stand trial. You have to have some type of hearing or by agreement where you present evidence that your client is incompetent, and you have to prove it by a preponderance of the evidence. It is not a defense. If you prove that your client is incompetent, that does not end the case or stop further prosecution. Competency is an ongoing issue, meaning you may meet with your client and your client may appear to be competent, but somewhere down the road that may change and they become incompetent. They may cycle. It may depend on whether or not they're taking medication, but it is something that you must always be verifying from the beginning of your representation until the conclusion. If your client becomes incompetent in the middle of a trial, then the trial has to stop, because competency is a due process issue. And as attorneys, we are obligated to evaluate our client's competency, to have an expert evaluate them if there is a good faith belief that the client might be incompetent, because we cannot proceed if they are. If the client is found incompetent, the goal of treatment, they will be ordered to treatment, and the goal of that treatment is simply to restore their competency. They may stabilize, they may gain insight into their illness, they may get better as a byproduct of the treatment that they receive, but the goal of the treatment is to restore competency. And once that is achieved, then the prosecution can resume. You can be placed under a court order to receive treatment to restore your competency for the same period of time as the maximum sentence that you could have received if you had been found guilty and given a sentence. So if it's third-degree felony, they have 10 years to try to restore your competency. And if you time out and you've served all that time between the jail and the hospital, they can refer you for a civil commitment if you meet criteria. Contrasting that with insanity, you are, same as competency, presumed to be sane. but it is an affirmative defense, which means that the state has to prove every element of the offense beyond a reasonable doubt. And then the defense must prove insanity by a preponderance of the evidence. Unlike competency, it is a static issue. The only question is, was the client insane at the time of the offense? Again, not before, not after, and not now. Competency, you have to be competent throughout the proceeding or being treated to restore your competency. You could be sane 3 years before you get to trial. It doesn't matter. It's only about the time of the offense. If you're competent, the client can decline to pursue an insanity defense or make any kind of mental health claim because it's not the same due process issue. It's a defense. It is our election whether to present that defense, and we cannot proceed otherwise against the client's wishes. If the client is found insane, then this is a complete defense. The prosecution ends. And they too are ordered to treatment. But the difference is that treatment will continue until the person is deemed no longer a danger to themselves or others. As an inpatient or an outpatient, they will remain in treatment until they are deemed no longer a danger to themselves or others. And just like with competency, you can time out. And if you time out, then you can be referred for civil commitment. So as you can see, these are very different concepts. They're looking at mental illness and its effect on our clients, but at different points in time for different reasons. There are very different processes and different implications from them. So let's talk about what else we need to know about competency and insanity defenses. And let's talk about who decides when to use these. So the Sixth Amendment lays out for us the typical balance of power in the attorney-client relationship. And we know that that means that there are some decisions that the client gets to make. There are other decisions, most of the other decisions that the lawyer gets to make. Sort of an exception to this rule is incompetency. As I mentioned, this is a due process right, and we cannot proceed against them if they are incompetent, and it is the lawyer's duty not to allow us to. And so if the client says, I don't care, I want to plead and take my back time and go home, lawyer cannot plead someone that they believe to be incompetent. So what do we do if the client decides, screw this, I'm going to represent myself, and then I only owe a duty to myself, and I want to take this deal? The Sixth Amendment also guarantees them that right to self-representation. So the question becomes, how, if at all, does it change when the client has a mental illness? And are there circumstances under which the court can say, I'm not going to let you proceed pro se? And there are two scenarios. The first scenario is the most common. If the court believes that the client may be incompetent, then the court is going to appoint counsel to that defendant, even over their objection, until that issue is decided, until competency proceedings are had or an evaluation is done. And if they are incompetent, the lawyer will stay on until they're restored over the defendant's objection. The second situation, which is a little weird and less common, is if an expert opines that the client is competent to stand trial, but only with the assistance of counsel. They couldn't represent themselves. They would be too incompetent to represent themselves. But with the assistance of counsel, if counsel is actually trying the case, then they are competent enough to proceed. And so they would be found competent but denied their right to proceed pro se. So what does this have to do with insanity? What we know is that if the client is competent to proceed, they can make any good or bad decisions. They don't have to listen to us. And that includes whether or not to present an insanity defense. If you are competent to stand trial, you may have the greatest insanity defense, and you don't want to use it, no one can make you. Because the court's reasoned insanity is an affirmative defense, which requires you to admit the underlying conduct. Yes, I killed that person, but I didn't know it was wrong at the time because of my mental illness. If you don't want to admit that you committed the underlying offense, the Supreme Court said in McCoy versus Louisiana, that is 100% your right. That is a Sixth Amendment right to decide the objective of your defense. And if you want to maintain your innocence at all costs, no one can override that decision. And that was a death penalty case that they made that ruling. Where that leads us next is to another Supreme Court case where we're dealing with scenario number two. What happens when the client is competent with counsel? Court said same thing. Looking back at McCoy, it's his right to deny permission to use an insanity defense, and defense counsel cannot do that over his objection. But they also said, yeah, if you're not competent to stand in trial without an attorney, then you can override his Sixth Amendment right to pro se, to represent himself pro se and revoke that status. So it's exactly the second scenario. I'm not going to go through everything in this slide, but it's important to know that the same is true for mitigation as evidence at punishment. If a lawyer can be found ineffective for failing to investigate and gather mitigation evidence, but if the client elects not to present that evidence, the client is competent, then the client will be held to that choice, and they can't later claim ineffective assistance of counsel on this ground. Okay, so if you want to pursue the insanity defense, where should we start? You're going to want to meet with the client immediately, as fast as possible, to get an assessment of what he or she may have going on. And if you suspect mental illness and that there may be a case for insanity, you're going to want to hire an expert immediately. Get them in there as quickly as possible. Even if they cannot yet do the evaluation, it is helpful to have them lay eyes on the client as close in time to the event as possible. It is super important that you do not show the client the discovery until all of the experts, including the state's experts, have spoken with them. A lot of times, clients who were psychotic at the time of the offense are going to have gaps in their memory. They're going to have delusional memories. Even though they're not delusional now, the memories when they think back are delusions. They're going to have gaps that they want to fill. And if you start showing them discovery, they will invariably blend what other people have said about what happened with what they remembered happened, and it will screw up your case in 100 different ways. So just don't do it. It's really important you choose the right expert for the job. A great place to start is, do you need a psychiatrist or a psychologist? One would be better if you have someone with a diagnosed mental illness, and the other is perhaps better if you have someone with an intellectual and developmental disorder. You're going to want to see what your client has and find the right person for the job. And then you're going to need money to pay for that expert, so you're going to want to file an ex parte motion. Always, always, always file it ex parte. Full stop, period, ex parte. Judges, if someone comes to you and asks for money for an expert or asks for an evaluation, please redirect them and tell them to file an ex parte motion. You should not file motions for competency and sanity as one motion. You need to file them as separate motions so that competency can be determined before the expert looks into sanity. These, if you get an opinion back from your expert, it will be disclosed to the court and the prosecutor later if you make issues of your client's mental illness in the case. But you need to see them first. You need to see what's in there to know what direction you're going. Is this a viable defense? Is there something in here that could be misconstrued or needs to be investigated further before anyone else is looking at it? You want to give your client a heads up so they know someone's coming to see them and why. And if the reports are filed, you need to make sure the court is sealing them. Judges, there is never a good reason that anybody wants to see these orders or these orders and reports after the fact. They use them to harass psychiatrists. They use them for a lot of improper reasons. They have protected HIPAA information in them. So if you are getting a report, or even, just like the ex parte orders and requests from experts, they should be under seal. You're going to start gathering your information as soon as you can, because hopefully there's going to be a lot to see. School records, past treatment records, videos from the arrest. You're going to want to gather whatever's out there, and you're going to want to use an investigator and probably a mitigation expert to help. If you want to use the insanity defense, you have to plead it. Even if your client has pled not guilty at magistration or arraignment, you can later invoke the insanity defense simply by filing a timely notice. Before filing that notice, it is important that you discuss these options with your client and make sure they understand the consequences of the different verdicts, particularly the NGRI. You don't want them to be under the same misconception as some people that if you get an NGRI, you just head home. You're not guilty and away you go. They need to know that they will be hospitalized and for an indefinite period of time and what that maximum period of time could be. It's fine if the client isn't sure if they want to use an insanity defense at the time that you file. Obviously, you need to know before you plead or go to trial, but it gives you the option to pursue the insanity defense. And once you make that decision, you have to give notice to the state, and because that is what triggers their right to have their own expert evaluate your client. And if your client refuses to be examined by their expert, then the judge can and should exclude any defense evidence of insanity. Statutorily, you have 20 days before trial to get this filed, but generally the judges are going to want to see it sooner. Okay, so it is possible and preferable for everyone to get the DA and the court to agree to an NGRI finding. I've had many that were done by agreement. So the question really becomes, how do we convince them that that's a good idea? I would start by documenting your client's history of mental illness. Sometimes it's your client's first break, but there's usually still some history. And focus on the specific psychotic symptoms at the time of the offense. Look at their criminal history, and if they have none, you're really going to want to emphasize that, obviously. If they have history, but it's not violent, that's also something to emphasize. Sometimes there's just nothing good in there and there's not much you can do. So you own it, you explain it, and you move on. But I think one other important thing to emphasize is if your client is now taking meds voluntarily versus under court order. You should present any other mitigation evidence you have, point out that, the failed attempts to get treatment, the barriers to treatment before the offense, when the client was in the community, if the client was homeless, you can point out that they had a lack of support perhaps at that time, but contrast it with the support that they have now. And most of all, you really want to emphasize the difference in your client now that your client is on meds and they're stable, and how this is how they could have been all along. There's a lot of talk about civil commitments, and as civil commitments exist now, it is unlikely that a civil commitment would have prevented whatever offense your client is accused of. But if your client later went to a hospital, for example, to have their competency restored, then and their competency is restored with treatment, that is proof that had sufficient treatment been available prior to the offense, then the offense probably wouldn't have happened at all, that it would have made a difference if the client could have gotten the proper care. What we need is a multi-step solutions that just aren't currently available. But if they had been, we probably wouldn't be here. And you can also emphasize that they got some of that treatment and they can continue to get that treatment and build upon it with an NGRI because they will be hospitalized. The real bottom line here is that most people living with mental illness are not violent. They are far more likely to be victims of violence. They can sometimes be violent if they have untreated psychosis, but they are not predisposed to violence. And if basic fairness isn't motivating your DA to agree, finding that, believing it's just unfair to punish someone for something when they didn't know it was wrong, or because of an untreated mental illness, then you should remind them that NGRIs actually protect the community better than parole, especially for first-degree felonies. For first-degree felonies, those people can be supervised for the rest of their lives, under court-ordered treatment for the rest of their lives. And unlike parole, they are only released from the hospital when multiple experts and a judge deem them safe for outpatient supervision. And their supervision continues. And the court can choose many ways to monitor them, and all of them are going to be better than how parole monitors their folks. If you do get an agreement, what you're basically going to have is a mini bench trial. It's just a hearing on the record where the state is going to present the probable cause affidavit or the indictment, and the court will find that they have met their burden of proof and established the elements beyond a reasonable doubt. The state rests. The defense will then introduce the report and opinion of insanity from their expert. Same thing. The court will find that they have met their burden and proven their affirmative defense. They rest, and the court will enter a finding of not guilty. And then judge is going to talk you through what that process looks after that finding. Obviously, if you can't get them to agree, then you're looking at a trial in front of a judge or a jury, and everybody is gonna have to meet their respective burdens. As I'm winding up, there's just a couple of things I want to talk about if you wind up going to trial. One of the big things people worry about is under Texas law, we cannot tell the jury what happens to the client after an NGRI. We cannot tell them they're not going home, they're going to a hospital for treatment. So how do we address that? And I think the answer is, like many things, we address it in voir dire. So if you, or voir dire, I guess it is here, you let the jurors educate each other. Start asking jurors, what do they know about the insanity defense? Talk about famous people that they may recognize who pled not guilty by reason of insanity. Where are they now? Are you satisfied with the way that case was handled? Do you think something should be done differently? The jurors can educate each other through your questioning of them to determine their biases about NGRI's defense. Again, this is a unique situation where you have three verdict options, and you're going to definitely want to make sure your client understands those, and you've talked about all of the ramifications. I think the biggest question often is, should your client testify? That's a dicey proposition for any of our cases, and it can be particularly challenging for people living with mental illness. Again, they're not necessarily going to remember everything about what happened. They're going to have some delusional memories about what happened. They may not have the confidence or the presence to testify or to withstand a cross-examination. That's going to be, you prep them as best you can and see what you think, but there will be some instances where you're going to need the client and you may not have a choice. In conclusion, there are a lot of difficult and important decisions that the clients and attorneys make with any criminal case. But for clients living with mental illness, there are additional challenges and decisions to be made. And some of the most important of them are going to be made by our clients. So, all clients may have, some challenges trusting us to participate in the process and trust our advice, but particularly with mental health clients who may have some paranoia or some distraction, but they come from a place where they've often been ignored or discounted. People think they're stupid, they can't make decisions, try to do everything for them, even when they're trying to help, and that may make them push back against your advice. So my advice to you would be to be careful never to treat them as broken or wrong in some way, and do what you can to engage them because you need them to trust you and to get buy-in so you can get them to follow your advice and the best strategy, and that they don't refuse to pursue the mental health defense. Because contrary to what many people believe, people don't like to be labeled as mentally ill. They certainly don't like to be labeled as insane. And so there can be a lot of resistance from clients. Nobody's dying to say, "Yep, I'm crazy. Put me in the hospital." It's just the opposite. And that's what I got.
Thank you so much, Krista. I know there are going to be some questions. We are going to move to Dr. Maureen Burrows.
Good afternoon. Thanks everybody for letting me do this and be part of this presentation today. Like Christy said, I'm a general and forensic psychiatrist. I did my undergrad at Vanderbilt and then all my medical training, residency, and fellowship at Tulane. I'm from Austin. I'm back in Austin. I've had my private practice here for the last 20 years. I primarily do forensic work. I do them, most cases are in the criminal court system, however, some in the probate and some in federal courts. up to now and 20 years in, I've done thousands of competency evaluations. I've done hundreds of insanity evaluations. I looked at my current case list and I have 40 active cases. Of those 40, there are 6 that are for insanity evaluations. The other ones are mostly competencies, some are for guardianship, and some are for civil commitments. But of the 6 that are for insanity, 3 of those are for murder, and 2 of those 3 are for multiple murders, capital murder cases. When I first started practicing about 20 years ago, I would get maybe 1 or 2 insanity evaluations a year. Now I'm getting probably 20 to 30 a year. I would also say when I first started, I was much less likely to find somebody not guilty by reason of insanity than I am now. I don't think that my opinion on insanity has changed. I think that is due to getting better referrals and having attorneys better understand the statute. In the beginning, I would get a lot of referrals for people who were maybe psychotic, but it was due to drug use. And so now I don't get those as frequently. So that gives you a little bit of background on who I am and why I'm even giving this presentation. There will be a little bit of overlap with what Ms. Chacona said, so bear with me. My next slide is about the definition of competency, because we do have a lot of people who confuse competency with sanity. And as Ms. Chacona pointed out, they're really 2 very different evaluations, especially on timelines. Competency is here and now. How does this defendant look here and now? Is their mental illness or their intellectual disability, is it interfering with their ability to work on their case and defend themselves? If it is, they are incompetent. Sanity, it's also a competency issue, but it is at the time of the offense. So at the time of the offense, did they have a mental illness, and did they, because of that mental illness, not know that their behavior was wrong? So it is basically a retrospective evaluation for the forensic expert. On the next slide, I've broken it down. I'm sorry, keep it here for 1 second. This slide, they're moving my slides. At the very bottom, that one little line, we're going to refer to it later, but I'm going to read it out loud. The term mental disease or defect does not include any abnormality manifested only by repeated criminal or otherwise antisocial conduct. So keep that one percolating and we'll circle back to it. The next slide, I have a list. This is what breaks it down into the 3 sections. And then go to the next slide. I don't know, some people are more verbal and some people are more visual, but the next slide is a slide that I will show if I go to trial to a jury. And it's actually a series of 6 slides where it lights up each section. And then this is kind of the final slide you get, but it's really helpful to have a jury see it and hear it multiple times through a trial, because remember, it's a really complex legal issue, especially for a layperson. So again, if you look at it this way, mental illness or intellectual disability, they have to have that. That's their first prong. The second one is they didn't know their behavior was wrong. And a lot of people forget this. It has to be linked to the mental illness. It can't be something else. It has to be because of the mental illness or the intellectual disability. And if you can show those 3 steps, then you have a good chance of not guilty by reason of insanity verdict. Okay, on the next slide, I guess it might be hard to ask questions, so I'll ask them and then answer them myself. But I'm basically wondering if everybody is aware of what the most common diagnosis is for somebody who is found not guilty by reason of insanity. If you go to the next slide, I have a pie chart that explains it. And as you can see, the majority of diagnoses that are found of defendants that are acquitted NGRI are psychotic. They have some sort of psychotic illness. In this case, it's 66%. There's actually a great slideshow from the Texas Health and Human Services that maybe when we send out the slideshows we have, we can give the link because it's a fantastic one and it's specific to Texas. This actual slide is based on the national averages. On the Texas Human or Health and Human Services slide, it breaks it down and says schizoaffective disorder is the number one, schizophrenia, then bipolar, then unspecified psychosis, then depression, then delusional disorder. I don't have this slide in my slideshow, but I'm just telling you, it's what also is interesting is that slide tells us that there were about 1,200, actually 1,195 defendants found NGRI in Texas admitted to inpatient state hospitals. So it doesn't cover the entirety of NGRI defendants because some don't go to the state hospital, but the majority do. And so, if you think about it, 1,200 over 10 years, that's not a lot of people that we're talking about. This is not a defense that is used all the time and successful all the time. On this pie chart, you can't really see it because it's such a slight sliver, but right between psychosis and mood disorders, there's a tiny sliver, and that is 0.4%. And that actually stands for people who are malingering and found not guilty by reason of insanity. So malingering is, lying is not really the appropriate definition. It is someone who is feigning or exaggerating mental health symptoms for secondary gain. So for either money, maybe in a civil case, or for a successful finding by a jury in a criminal case. So in a retrospective study of 5,000 acquittees found not guilty by reason of insanity, they found that 0.4%, so of the 5,000 people found NGRI, only 20 were found to have been malingering. So as you can see, it's really rare to have somebody malinger successfully and obtain an NGRI. I think part of that is it's not just one interview when we are evaluating people for an NGRI. Typically, I go back multiple times. I spend upwards of 20 hours in some cases with the defendant. And I'm looking at records from the entirety of their life. So it would be unusual that somebody who starts faking it when they're in jail and realize this could be a helpful defense is going to have supportive evidence throughout their life showing that they actually do have a serious mental illness. And so it's not common that we have malingerers. The other thing is we do testing for people who are malingering. There are specific tests, especially for psychosis, that will tell us if somebody is faking. I mean, certainly we do our own screening, but then there are the tests like the SIRS. It's a couple hundred question test. There are tests like the MFAST, and then and those are specifically targeted towards people who are malingering psychotic symptoms. And for those of you who don't know what psychosis is, I'll just say on the side, it's basically a detachment from reality. So you can have psychosis if you're having hallucinations, if you're having delusions, which are fixed false beliefs, or if you're having disorganized thoughts or speech where you're not really making sense or it's kind of jumbled. Those are all symptoms of psychosis. So anyways, we have the specific tests like the MFAST and the SIRS, but we also have general personality tests like the Minnesota Multiphasic Personality Inventory, the MMPI, or the PAI, the Personality Assessment Inventory. And those test for a lot of things. It looks at diagnoses across the board, not in personality disorders, but embedded in those tests are validity markers that will tell us if people are exaggerating or feigning or even minimizing symptoms. So again, it's not that we are just saying, I don't think you're faking, so I'm just going to go with it. We are doing a lot of research and a lot of investigation and a lot of testing to exclude people who are malingering. Okay, on the next slide, we're going to start talking about some common misperceptions. I think it's very common, as I alluded to earlier, that people think this is a prevalent defense and that it's used all the time. Like I said earlier, in Texas, there were almost just short of 1,200 in 10 years found NGRI and put in an inpatient hospital, state hospital. There was a study that was done by Paswack and Seidenzahl, and they found that the public grossly misestimated the prevalence of insanity pleas, believing that it was used in, I can't believe this, but 37% of all felonies, and that its success rate was 44%. So this was a study that they did. And in actuality, it's only raised in 1% of felony cases. And of those 1% of felony cases that it's raised in, only 25% are found successful. And what's even more important is of those 25%, the majority of them are agreed upon by both sides and don't go to trial. The next slide. Another common misperception is that the insanity defense is highly contested defense. And like I just said earlier, it's not. It's most of them are agreed upon. And in fact, they did a study for 7,000 insanity trials that they found, or insanity cases, that nearly more than half had an agreed upon finding. And the highest state was Oregon, where they had 86% of successful insanity defenses agreed upon. In my career of 20 years and the hundreds, if not 1,000 sanity evaluations at this point, I think I've had 4 trials, maybe 5. So as you can see, it's really rare. Next slide. So lastly, as far as common misconceptions, there is this belief that there's no accountability. And Ms. Chacona, I believe, touched on this, but that is not the case. NGRI acquittees typically spend substantial periods of time in forensic facilities, sometimes exceeding the time that would be spent in prison if they had been found guilty of the offense. And again, that's based on 3 different studies. And in fact, some people or some acquittees spend up to 50% longer in the hospital than those convicted of the same crime and just sent to prison. So this is not the easy out or the shorter out for most cases. Okay, the next one, I just want to give a little bit of what we're looking for as an expert when we do these evaluations, especially when I'm screening or talking to an attorney or a judge. What I'm looking for, and this is what is supportive of maybe being somebody who was insane at the time, is that there's no rational motive. If I see a crime where somebody killed their spouse and they inherited $3 million, that's a rational motive. I mean, that might be a real good reason for somebody, I mean, not a good reason, but it is a rational reason to have committed that murder. If I see somebody do an act or a criminal act and it makes no sense at all and nobody can explain why, like I had a man years ago, he was on an insanity unit at the state hospital in Louisiana, and he had killed his dad, who was by all accounts his closest supporter and friend. This was a long-term schizophrenic. He literally disemboweled him. He cut him from chest down, took everything out, and then stuffed random household items in him and put him in the car and drove him around town. So again, that's bizarre. There's no rational motive for that. So that is a sign that somebody might have been insane at the time. The other thing I'm looking for is I've had defendants call police and say, I just killed this person that is an alien, or they'll say, I just killed this alien. You need to come, you need to get him off my property. So they're calling the police for assistance, whereas somebody who is committing a crime and knows what they're doing is wrong and is trying to hide it is unlikely to call the police for assistance. Another thing that might be supportive of an insanity defense is when somebody is arrested and they are shocked and don't understand. If they are saying, and it's not that they're denying that they've done anything, but they are shocked because they think they have done something right or appropriate. Okay, next slide. The next two slides are examples of things that might tell us that this is not somebody who is appropriate for an insanity defense. So if somebody is attempting to conceal their identity at the time of the crime, maybe they're wearing masks or they have a disguise, gloves, or they commit the crime in darkness where they're less likely to be seen, at a time of day that they're less likely to be seen, or they give a false name if somebody comes across them at the time of the crime. Those are all things that would make me think, maybe this person knew what they were doing was wrong. Another thing would be if somebody attempts to conceal the crime in and of itself, like hiding the weapon. I had one where somebody recently threw the knife into the underground, the sewage drainer. Or if somebody tries to clean the scene so you don't see any evidence, or they try to hide the victim by burying them, or destroy incriminating documents. All of those are evidence of somebody attempting to conceal a crime, which makes you think that they would know what they were doing was wrong. Another one is if they attempt to escape or avoid detection, like leaving the scene or trying to evade police or going on a long car chase, giving a false alibi, or lying to the police. Next slide. And then these are four more things that I look for that would be not supportive of insanity. One is if the person expresses remorse or guilt immediately afterwards. I'm so sorry. I shouldn't have done that. In and of itself, it doesn't mean they weren't insane, but it certainly lends credence to the idea that they did not, or that they knew what they did was wrong. Also, the absence of active symptoms of mental illness. If somebody commits the crime and there's no active mental illness and they are completely fine when they're talking to detectives, and 2 months later, after they've talked to all the jailhouse lawyers and gotten advice about an insanity defense, starts manifesting mental illness signs, we might think that's maybe not a good insanity defense candidate. And also, maybe they just don't have any signs of mental illness at the time, and that's not a good candidate. Again, if they're calling the police to report a crime, then clearly that is a sign that they know that they've done something wrong, especially if they're labeling it a crime. And then we obviously look at statements at the time that they give to police that are on body cams or that witnesses heard that would indicate that they knew what they were doing was wrong. Okay, next slide. I know we're flying through this. So this is a section on common errors that experts and attorneys might have when they are considering an insanity defense. Next slide. One is confusing voluntary intoxication with insanity. At the beginning especially, had so many people call and say he was psychotic, he didn't know what he was doing was wrong. And that might be true, but if that's because they used meth for 3 days prior to the offense, then that does not make them a good insanity candidate, because voluntary intoxication causing symptoms of psychosis that are temporary, that lead to the inability to know what you're doing wrong, it's excluded from an insanity defense. The next one where people get confused is they hear of a very horrible crime and think nobody in their right mind would do that. They had to have been insane. And that's kind of a layperson's interpretation. I don't know if any of you guys recognize this guy, but this is Ted Bundy. And, he was a serial killer who kidnapped, raped, and murdered a myriad of young women and girls. He ultimately confessed to 30, but they believe that there were more victims. He was charismatic, handsome, and exploited all of that to gain trust of his victims. He would usually feign some sort of physical impairment, such as injury, or he'd impersonate an authority figure, and then he'd bludgeon them and make them unconscious and then rape and strangle them. Some of his behaviors, for example, he would do performing sexual acts with corpses until decomposition and destruction by wild animals made further interactions impossible. And he decapitated about 12 victims at least. And so again, somebody on the outside might say, wow, he had to be crazy to do that. But his biographer, Anne Rule, I think her description is very telling. She described him as a sadistic sociopath who took pleasure from another human's pain and the control he had over his victims to the point of death and even after. Bundy once described himself as, quote, the most cold-hearted son of a bitch you'll ever meet. And this is a statement that his attorney, Polly Nelson, who was a member of his last defense team, agreed with. She said Ted was the very definition of heartless evil. So remember earlier at the very beginning when I was saying, remember this one sentence from the insanity, the part of the code that references it. And in that sentence, it says, mental disease or defect does not include any abnormality manifested only by repeated criminal or otherwise antisocial conduct. So in the DSM-5 TR, the reference book that we use in making criteria for diagnosis, there is a diagnosis for antisocial personality disorder. We don't have sociopath or psychopath in the DSM-5, but that would definitely be under the section of an antisocial personality disorder. That is a diagnosis. Some people would say it's an illness. I think it's more of a descriptive title to help us understand these very disordered pathological people. But because of this one statement, that does not get put in as somebody who has a mental illness. It is not, it is excluded from the insanity defense. Next slide. Another mistake that people commonly make is thinking psychosis means you have to have been insane. And there was a lot of this on this defendant's trial, which went on and on. I don't know if you recognize him. This is Jeffrey Dahmer, serial killer and sex offender. And he was actually diagnosed as having a psychotic disorder. What that diagnosis was varied per expert, but ultimately they felt like he had a psychotic disorder as well as a personality disorder. But the issue is, even with his psychosis, he knew what he did was wrong. He planned his acts, he covered them up. So he was not ultimately found insane. So again, just being psychotic and just having a long-term psychotic disorder does not in and of itself make you insane. Okay, next slide. This is the last one I'll bring up about common errors. This is where people start, especially attorneys, will start using mitigating factors and thinking that makes the person insane. So I've literally had people say, you know, look, this person came from a low SES, socioeconomic system. They were neglected, they were abused. I mean, how could they have known what was wrong? That's not what we're looking for here. I know we have another presenter. I just have two more slides I want to go over. The last, if you could forward, it's a little pop quiz, but since I can't see your hands, I'm just going to give you the answers. How long can a person be acquitted NGRI, or a person who is acquitted NGRI be committed to a facility or ordered to receive outpatient supervision? Krista Mischikona did touch upon this, but I want to make sure everybody knows they can be committed and under court supervision for as long as the maximum term provided by the law for the offense. So if it's a second-degree felony, they can be committed under court supervision for up to 20 years. If it is a third degree, it's life, up to 99 years. So again, there's a lot of control that can be exerted when somebody is found not guilty by reason of insanity. And then the last slide, Ms. Chacona touched upon this as well. The jury is not informed of the consequences of an NGRI verdict prior to their deliberation. And I do believe that that is a real problem and concern. I think it is something that needs to be addressed in the legislation or the next legislative meetings, if possible. Again, we'll send out my contact information if you have any questions. Hope this was helpful, and thanks for coming.
Thank you, Dr. Burrows. It was awesome. There are
Thanks.
3 good questions in the Q&A that perhaps you could type answers in case we're running out of time, but we'll try to circle back.
Okay.
But yes, we're excited now to hear from Judge Cassiotti. It's in the correct view, Judge. Thank you.
Now if I could just unmute myself, I got it. All right, thank you. Well, I'm going to talk to you about post-acquittal procedures after an NGRI finding. And as has been mentioned, there are some people who believe that when they hear that a person was found not guilty by reason of insanity, that that person received a get out of jail free card, that they are going home. Let's see, I'm trying to advance my slide here. Hang on 1 second. There we go. That they're going home, they're avoiding punishment. And while NGRI is a verdict of acquittal, it is different from an ordinary acquittal. It is far from it, actually. The finding of NGRI triggers a process, a legal process that is completely different, that occurs after the person is found not guilty by reason of insanity and can lead to involuntary, court-ordered treatment in a mental health facility or a residential care facility, ongoing treatment, and potentially years of judicial supervision or oversight. So we're going to spend some time talking about these post-acquittal procedures and specifically what happens after a defendant is found not guilty by reason of insanity. So the first thing that a court must do is immediately make a determination of dangerousness. So the court must find or determine if the offense for which the defendant was convicted involved conduct that caused serious bodily injury to another person, placed another person in imminent danger of serious bodily injury, or consisted of a threat of serious bodily injury to another through the use of a deadly weapon. Why is that determination so important to be made right after a finding of NGRI? Because that determination, that dangerousness determination, will impact whether the criminal court retains jurisdiction for purposes of court-ordered treatment and supervision. So let's kind of divert for a minute and talk about non-dangerous acquitted persons. So let's say that the court makes its determination that the defendant did not engage in dangerous conduct. So at that point, the court must then evaluate the evidence of mental illness or intellectual and developmental disability that was presented and determine whether there is evidence that the acquitted person is a person with mental illness or intellectual and developmental disability, which I'll refer to as IDD from here on out. So if the answer to that question is yes, then the court would transfer jurisdiction to a court with probate jurisdiction for purposes of civil commitment proceedings under the Texas Health and Safety Code. So at that point, the criminal court's jurisdiction is going to end, and jurisdiction of the person will be now mandated by the civil court. And that civil court will be the one to make a determination as to whether the acquitted person should be committed involuntarily for mental health services. So the court can also order that the acquitted person remain in a jail or another suitable place for those civil commitment proceedings, but the state has to initiate those proceedings promptly. So if the answer to the question is no, that there is not evidence to support that the acquitted person is a person with mental illness or intellectual disability, then that acquitted person is released and no court has jurisdiction over that person any longer. So moving back to dangerous acquitted person. So the court determines that the offense involved conduct that was dangerous conduct. That we get the question a lot, and Dr. Burrows just talked about this, is how long is the court going to retain jurisdiction over that person after that NGRI finding? Well, two things can happen. One, the court can discharge the acquitted person and terminate its jurisdiction early, and that's because it determines that the acquitted person no longer has a severe mental illness or IDD, or is not likely to cause serious harm to another based on their severe mental illness or IDD, or its jurisdiction automatically terminates because the acquitted person times out, or you might hear also the term maxes out. And Dr. Burrows went over what that means. So it means that the total period of institutionalization and outpatient treatment under the court's jurisdiction, so that means any court-ordered treatment after a finding of NGRI ordered under Chapter 46C equals the maximum term of the offense for which the person was found not guilty by reason of insanity. So again, you heard the example. If they were acquitted by reason of insanity of an offense that carried a 10-year maximum term, then they can be committed for those 10 years. One thing to note here, any time that the person spent in a state hospital facility or in a jail prior to being found not guilty by reason of insanity, say, for example, if they went because they were incompetent to stand trial, that does not count towards their maximum term. All right, so we're at the point of what happens once a dangerous determination is made. So person's found not guilty by reason of insanity, court immediately makes the determination that there was dangerous conduct and retains its jurisdiction. So now the court commits the acquitted person to a facility designated by the Health and Human Services Commission for evaluation and treatment. And generally speaking, this is all going to happen at the same time. So this within that same hearing, that same time frame that the finding or the verdict of NGRI is returned, the court immediately makes its determination of dangerousness and then commits the person for a 30-day commitment, again, for evaluation and treatment. And that's evaluation of the acquitted person's current or present mental condition. The court also has to hold a hearing within 30 days of acquittal to determine the disposition of the acquitted person. So in other words, what's going to happen to them from that point. And then also requires a report to be filed with the court from the facility at least 4 days before that hearing. So two things I want to mention is first, the court will order that a transcript of the medical testimony and vital statistics, other relevant facts are sent to the mental health facility so that they have that information to inform them when making their evaluation and providing the treatment. And additionally, we have this issue of the wait list. So in our experience here in Tarrant County, nobody is ever sent to the state facility the day that they are found not guilty by reason of insanity. And they don't go the next day, and usually they don't go within the same week. And for the most part, it's usually some weeks before a person is transferred to the facility. And you'll note the code is requiring the court to hold a hearing within 30 days of the date of acquittal to determine the disposition. So practically speaking, that's really impossible for that to happen in most cases. So what we do in Tarrant is we consider the time frame to start, the 30 days to start from the date of their admission to the state facility. That can get kind of tricky because, you may not always know when the person actually leaves for the facility. So what we've done is develop a process by which, we get the jail to inform us when the person is transferring or when they're booking out to be transferred to a state hospital facility. And at that point, generally speaking, the state will request the court to go ahead and set a hearing 30 days out so that the facility knows when that report is due. And that kind of makes that process a little more efficient and seamless. All right, so the report to the court has to address that the acquitted person has a mental illness or an intellectual and developmental disability, and if so, whether it is severe. Additionally, whether as a result of the mental illness or IDD, the acquitted person is likely to cause serious harm to another, whether they meet civil commitment criteria under the Health and Safety Code, and whether treatment and supervision can be safely and effectively provided on an outpatient basis. At the disposition hearing, the court is going to address much of the same material that was addressed in that report. So the hearing is conducted in the same manner as an application for involuntary commitment under the Texas Health and Safety Code. The state has the burden by clear and convincing evidence, and the court will address, does the person have a severe mental illness or IDD? As a result, are they a danger? Are they likely to cause serious harm to another? And can appropriate treatment and supervision be provided on an outpatient basis? So the possible outcomes from a disposition hearing is that the court can order inpatient or residential treatment or commitment if the grounds for an inpatient order are established. The court can order outpatient treatment and supervision if grounds for an outpatient commitment order are established. Or if the state fails to establish either grounds for inpatient or outpatient commitment, but there is evidence to support or provide a reasonable basis that the person is the proper subject for civil commitment proceedings, then the court can transfer jurisdiction of the person over to a civil court with probate jurisdiction for those proceedings. And again, if that happens, then the criminal court loses jurisdiction over that person at that time. And then lastly or finally, if none of the above are established, then the court must discharge the acquitted person from all court-ordered treatment and order their release. And at that point, again, none of the courts, neither court, civil or criminal, has jurisdiction over this person. So a court shall order an acquitted person to a facility that is designated by the Health and Human Services Commission, or HHSC, for a period of 180 days if it finds that the person has a severe mental illness or intellectual disability. As a result of the mental illness or intellectual disability, they're likely to cause serious harm to another if they are not provided with treatment and supervision. And inpatient and residential care or residential treatment and care is necessary for the protection of society. So at times, a acquitted person, based on the nature of their offense or based on their behaviors and symptoms, may be designated to a maximum security unit by HHSC. And so if that occurs, they must be presented to a review board within 60 days. And that review board will determine, based on their evaluations and other information, that whether the acquitted person is manifestly dangerous. So if they find that they are not manifestly dangerous, then the acquitted person has to be transferred to a non-maximum security unit or facility or a state-supported living center within 60 days from admission to the maximum security facility. So outpatient or community-based treatment can be ordered by the court if it finds that the acquitted person has a severe mental illness or IDD, and as a result is likely to cause serious harm to another if they are not provided with treatment and supervision, and the state fails to establish that inpatient or residential care is necessary for the protection of others. And this order is for 12 months. When considering whether to order outpatient or community-based treatment and supervision, the court must have as its primary concern the protection of society. And so it also must consider and approve a comprehensive outpatient treatment and supervision plan for the acquitted person. So when we're talking about outpatient here, we don't mean that someone is just going, back into the community and to find their own resources or their own services. There has to be a plan. That plan has to be approved by the court. It has to be a comprehensive plan, and it has to be available and provided to the acquitted person. So if your community doesn't have those types of resources or services available that can be provided, then that's generally not going to be a workable situation to where the court can order outpatient treatment. Again, when considering the protection of society, the court may order treatment like participation in a prescribed regimen of medical, psychiatric, psychological care, to include psychoactive medication. And the court can also order supervision of the acquitted person by the appropriate community supervision and corrections department or a facility administrator of a community center that provides mental illness and or IDD services. Also, the court can order the acquitted person to participate in a supervision program that is funded by Takumi. So the outpatient or community-based treatment and supervision provider, or the person responsible for administering the regimen of the outpatient treatment, is responsible for monitoring the acquitted person's condition. And that's a continuing responsibility. And they also have to monitor whether the acquitted person is compliant with their regimen of treatment and supervision. And so again, the outpatient provider that is responsible for administering the regimen of treatment has to inform the court and the prosecutor if the acquitted person fails to comply with that regimen at any point and becomes likely to cause serious harm to another. So they become dangerous. The treatment facility that where the acquitted person is committed has a continuing responsibility during the commitment period to determine if the acquitted person continues to have a severe mental illness or IDD and is likely to cause harm. And if so, whether treatment and supervision cannot safely and effectively be provided on an outpatient basis. So the facility has to notify the court and seek a modification of the order if that acquitted person is no longer has a severe mental illness or intellectual disability, intellectual and developmental disability, is no longer likely to cause serious harm, or treatment and supervision can be provided safely and effectively on an outpatient basis. If the facility is going to seek modification of a commitment order, they must do so at least 60 days before commitment expires. And they have to provide evaluations. But again, this could be done at any time that this criteria is met. So the court can modify its treatment orders from inpatient to outpatient and vice versa when deemed appropriate. So improvement or stabilization can lead to outpatient treatment. The request can be made by an acquitted person, by an inpatient facility, or the prosecutor, and the court shall order outpatient treatment if it finds by preponderance of the evidence that outpatient treatment and supervision and can be safely and effectively provided on an outpatient basis. And by the same token, non-compliance or danger can lead to the return of inpatient treatment. So the court, on its own motion or on the motion of any interested person, may revoke or modify an outpatient commitment order if it's shown by clear and convincing evidence that the person has failed to comply with treatment and supervision in a way that indicates they will become likely to cause serious harm to another, or they have become likely to cause serious harm to another if they continue in outpatient treatment. So notice that the language is that the court may revoke or modify. So the court doesn't necessarily have to revoke the order and send the person back to a facility. They can amend or modify their outpatient order to include more stringent terms in hopes to keep them in the community, but also keep the community safe. The court will review its treatment orders on an annual basis. So the request to renew must be filed no later than 30 days before a commitment order expires. And that's whether it's for an inpatient renewal order or an outpatient renewal order. The request can be filed by a prosecutor, by an inpatient facility, or an outpatient provider. It has to explain in detail, why they are requesting a renewal of the order. And it also has to be accompanied by a certificate of medical examination for mental illness, which we often refer to as a CME. And that CME must be signed by a physician who examined the individual within 30 days preceding the filing of the renewal request. Also, if an inpatient facility is requesting a renewal of that inpatient order, then it has to be, they must also explain in detail why outpatient treatment and services and supervision is not appropriate. So the court shall renew an order for inpatient or outpatient treatment only if it finds by clear and convincing evidence that continued mandatory supervision and treatment is appropriate, and that renewal order will authorize continued court-ordered treatment and supervision up to 12 months. All right, so we've heard a couple of times now from both of the prior presenters that NGRI is not, a common situation, that the insanity defense is not raised very often. I think it was stated that it was raised in 1% of the cases or less than 1%. And that holds true here in Tarrant County. So I think there may be a misperception that there several individuals, are out there that are found not guilty by reason of insanity. And that just doesn't really remain true. We actually have a very low volume here in Tarrant County, and we're a large urban county, especially when you compare it to the number of cases that are filed each year and the number of cases that are disposed each year. So here in Tarrant, who are under current commitment orders, we have 25 individuals who are under an inpatient commitment order. And kind of notably, we've got at least one individual who has been under an inpatient commitment order since 2001. We also have one person who is currently under an outpatient commitment order, and they were ordered to outpatient treatment just last year. You can see that on an annual basis, we have very few individuals who are found not guilty by reason of insanity. To date this year, we've had 3. Last year, there were 2. In 2024, we had 5. And in 2023, we had 3. So again, not very many people, at least in Tarrant County, that are under NGRI commitment orders or that are found not guilty by reason of insanity on an annual basis. So want to just leave you with some practical tips. One is, and the most important, I think, is to establish a process to track individuals, at least the cases of individuals who have been found not guilty by reason of insanity in your county. I mean, we've heard a lot about and walked through all the processes and procedures that must take place when post-acquittal, when a person is going through that process and is committed either inpatient or outpatient. And there are many deadlines that have to be met. So it's really important that you find a way, depending on what your role is, to track those cases to make sure that deadlines are met, that requests for renewal or modification are timely made, and that you know where these individuals are committed, whether they're an inpatient, which hospital they are in, if they're outpatient, who is providing those services. So one example I have is outpatient renewals. That is something that we have struggled with here in Tarrant County because it is sometimes hard to find a physician to do a CME, an evaluation that has to accompany a request for renewal for outpatient in the community. And so it's important to get ahead of that and make sure that you're on top of those deadlines and timelines and are communicating to make sure that that can happen. Because when the focus is treatment and community safety, we don't want an order to expire and an acquitted person kind of falling through the cracks. The other thing I would say is, and kind of to back up a minute, the way we've done that is just with a simple Excel spreadsheet and marking down when a person is found not guilty by reason of insanity, what the deadlines and timelines are for those commitments, and then again, the dates of which we need to start reaching out to make sure that we've got the proper documentation to make a request for a renewal. When I was with the DA's office, and that's what we were doing. So the other thing I would mention is develop points of contact. Depending again on your role, make points of contact at the facilities, with outpatient providers, the prosecution, the attorneys representing the acquitted persons, the courts. It's important to have those lines of communication so that everyone is on the same page and everyone is fully aware of timelines, deadlines, and what is expected and required. And then again, communicate. Make sure that everyone knows what's going on. Again, when the focus is on treatment and community safety, we just don't want anyone or any orders expiring and people falling through the cracks. And that is all I have. Thank you.
Judge Cassiotti. That was an incredible presentation. So much information from all three of you. But I want to point out one thing. We have time, I think, for one question that Dr. Burrows wanted to answer. Kylie, if you'll put up the QR code for the CLE. And I wanted to point out that we have technical assistance. So if you're a county that may just get one of these every few years, we can connect you with sort of the knowledge base of other people who do this more often, and you don't have to do it completely alone. HHSC also has a technical assistance center. Between the two of us, we can connect you. So, okay, there's the QR code. And then the question that Dr. Burrows was going to answer is, why does the Code of Criminal Procedure prevent getting an eval for insanity while a person is incompetent?
I don't actually know the legal reason. I can tell you what I was taught was that you really need the defendant to be competent and be able to consent to the evaluation and understand what they're being evaluated for. This does not mean the expert can't meet with the defendant before they're competent. I think that's incredibly helpful. And in fact, most of the attorneys I know and I work with regularly know that if they even have an inclination that this may be an insanity, I want to be in there as soon as possible, documenting symptoms and what they looked like when they came in. So you can document and see what they look like and talk to them and at least have a record of symptomatology at the time or closest to the time without fully doing an insanity evaluation. But we need them competent for consent reasons. And also when they are incompetent, a lot of times they're not making sense. And so it's hard to get background history from them. It's hard to get information that's necessary to do the full evaluation.
Thank you so much. And I want to thank Attorney Krista Chacona, Dr. Maureen Burrows, and Judge Nelda Cassiotti. They put so much time and effort in this, as you can tell. And since it is so much information, there will be a toolkit. We'll be doing one-pagers. We will try to repackage this information in many ways to try to break it down. And then tune in again in July and in August for parts 2 and 3. Thank you all so much.
Thank you.